Hello, Katherine Hensel West. I am Catholic and I'm a litigator practicing. My office is here in Toronto. I practice, well, I have clients across the country, and I do primarily litigation. I was counsel with Brian Greenspan for the Advocate Society in the recent Supreme Court of Canada case of Katherine, which was on Aboriginal jury representation. And I practice Aboriginal law, but my litigation practice is focused exclusively on the human rights and perspective of Indigenous people in Canada and Indigenous communities. Also counsel at for Katherine, in the middle there, wearing the orange, is Jessica Orkin. She practices she's a litigation lawyer at Sack Goldblatt Mitchell, LLP. She has a broad litigation practice that includes criminal, civil, and administrative law, with an emphasis on constitutional, human rights, Aboriginal rights, and access to information matters. She's appeared at all levels of court throughout Ontario and at the Supreme Court of Canada, obviously. And she's going to talk about all the things Aboriginal jury representation. To my immediate right is Christa Big Canoe, a good friend of mine from law school. She's a Anishinaabe Kwe who is currently the executive director for Legal Services. What are services? Right, sorry. At Aboriginal Legal Services of Toronto, a frequent perennial intervener at the Supreme Court of Canada and counsel at numerous coroners' inquests and other litigation matters, as well as providing a legal aid clinic or a law clinic to Toronto's and really Ontario's, although don't tell legally that, Indigenous population or Indigenous community. And to the far right is Stephen Ford, another colleague of ours in the Indigenous bar. Stephen is Haudenosaunee. He's a member of Tyendinaga and has a constitutional and criminal law practice. When I was in Ladue Court, he was often there as one of the only, there's only ever a handful of criminal defense counsel in Ontario who are Indigenous lawyers themselves, and Stephen is one of them. So, to begin, who's going to go first? I think Jessica wants to go first. Sure. Yeah, she does.
She's the most versed on the litigation aspects. So I'm just going to start by saying there is a case coming up in Thunder Bay, which up until Monday I would have said publicly, but now has a pub ban on the name of the case because I'm happy to say it privately, but we're representing Mr. W on his challenge to the jury roll for the second time, and there is a pub ban on his name, just to let everyone know if for some reason that we're going to be publicized. The reason for it is that it's not easy to challenge the jury roll. In the event we are unsuccessful, we're not sure that we wish potential jury members to know that Mr. W challenged their impartiality and inclusion on the roll. So that's just to start off to explain why I'm going to call him W. The case of Katherine is when I first became involved in the Aboriginal jury issue. We followed on the coattails of Julia Faulkner and Julie Roy and ALST. Were you ALST yet? Not yet. Okay, so we weren't yet on your coattails. Kim's and Jonathan's coattails at ALST, where they had uncovered the problem of inclusion of on-reserve residents in the Kenora jury roll. And Mr. Katherine, trial had concluded and he had been convicted, but he hadn't yet been sentenced to the point that became public knowledge. And we sought on appeal to get disclosure, you know you have something that is potentially useful and interesting when the Crown tells you that not only do they not want to give you disclosure, but they want to bring a motion about how your case shouldn't be heard at all. And they want it to be heard in advance because they don't want to give you disclosure to argue that motion. So we had that occur, and so we were scheduling the disclosure motion at the point that Karen McRae came out. And the Crown decided, as they put it, that it was in the public interest to provide disclosure at that point. And we then spent another year developing the fresh evidence for the Court of Appeal in Catholicus. And what that evidence showed, essentially, was not a surprise to anyone, I think, who's engaged in the justice system, particularly in the North, when it comes to Indigenous peoples. It was a complete lack of regard or care or attention being paid to the inclusion of reserve residents on the rolls. And it mirrored the general state, I think, of the justice system up there with the circuit courts and with the reserve justice system. The Court of Appeal was, well, two members of the Court of Appeal were found that the roll was not constitutional, and that was now appealed to the Supreme Court. We argued that last October. We haven't yet had a ruling. In the meantime, I did a challenge in Mr. W's case in Thunder Bay last year, and we won last year. So the Thunder Bay jury roll from 2014 was found to be deficient as well. The ministry has put a lot more effort into this year's jury roll. There are many more lawyers working on this application than there were last year. Not on my side, but on their side. I think that we will find that their witnesses are more prepared, and I expect that we may not have the same results in terms of the application's result. I think in the end, the juries are not looking any different than they were 5 years ago. The participation and response to jury requests is still incredibly low, and in some ways, it's, I think, perhaps even lower, because people have heard about the issues now and know what that form is when it arrives. And so there is, in some ways, I think, and I've seen this just reflected sometimes in the disclosure, there is a more intentional refusal to fill it out amongst some. There is also a list of volunteers who have been collected and some good work being done by the implementation committee, but that is a very, very long-term process before I think we see results from that. And Christa knows more about the implementation committee's work and the parallel work that's being done for coroner's juries, because in some ways it's easier to have an impact on the composition of a coroner's jury, where the concern about random selection of jurors. In a criminal trial, as defense counsel, I think defense counsel would have a feeling of suspicion if someone really wished to be on a jury. You would wonder what it was that they wanted and why it was that they wanted to be there so badly. And so the selection of individuals in a non-random manner to be on a jury in a criminal matter is really problematic. And that then means that it's very hard to change the raw numbers when it comes down to the jury roll level. From the jury roll, if you have, I don't know, in Thunder Bay, the jury roll in 2014 had 1,300 people on it. There were 27 reserve residents on the roll, and there had been 250 notices sent out. And so you had a tiny response rate, and by the time you get to a panel, there were no Aboriginal on-reserve residents on the panel list just by process of random selection. But on the coroner's inquest side, there is the ability to have a more directed role in picking the people who end up on the jury for particular cases. And so they have recently in Ontario, is it now in force? Okay, so there's a new regulation, which Christa knows more about than I do, which allows for a volunteer selection for the jury roll. So people can be picked randomly from a list that is people who wish to be on juries for coroner's purposes. And from the perspective of inquest juries, that offers a different way of engaging, and one that I think would be perhaps more successful at getting real representation and participation. I'll stop there. Okay, so any way to show Christa Big Canoe, no quad, on Big Quay, the gig dotum, Georgina Island, Wasina Donjaba, Ogina Quig, and Majig Gakina, Wabala, Did, Whelan, Wetch, and thanks for having me on this panel. I just said my name again. I talked about the fact that I'm from the honored plan on Georgina Island First Nation. There is no translation for legal director, so it's the chief lady of the advocates, which is the lawyers, is the best way I could understand how to explain it. And go with that general. Yeah, I think so too. I think that's going to be my new title, the chief lady of the advocates. So, I've been with Aboriginal Legal Services. So I'm just going to start with, I've been with Aboriginal Legal Services for 4 years now. And it's been a flying 4 years of non-stop go, and it's mostly been a result of the hard work of my predecessors at Aboriginal Legal Service, Kim Murray, who is now the ADAG of Aboriginal Justice in Ontario, the first Aboriginal person appointed in that position. And that the position was created as a result of all of this work, of all of these challenges and inquests, of the criminal challenges and litigation, and of the Yakaguchi Review. We often call it the Yakaguchi Review. Its formal name is Ontario. Actually, I got it up on my iPad here. But the Yakaguchi Review is the First Nations jury representation in Ontario, but it sort of colloquially is referred to as the Yakaguchi Review because it was former Justice Frank Yakaguchi who headed up the team, did the review, and put out the report. As a result of the report, so I'm stepping you back. As a result of the report, what happened was some of his first recommendations were that you need an implementation committee in order to make sure these recommendations are put through. You need an assistant deputy attorney general for Aboriginal, and then a number of other recommendations. And one of those recommendations I'll talk about today was recommendation 17 that said you need to have volunteers when it relates to coroner's inquests. But essentially, I literally stepped into my position and was told, here, these are these 4 inquests we've done that were challenging, and I came in just as Pierre was being reviewed by our office and by Faulkner's office, Julie Faulkner. And so it's funny because we always refer to it as Pierre McCrae, and Mr. Faulkner always refers to it as Nan and Eden. Because he's the only one. He's the only one, because his part of the challenge was Nan and Eden decision. And so, but he did an immense amount of work on the Pierre McCrae too. So essentially what had happened, and I'm taking you back a step, because I think this is the only way to contextualize it, and as a First Nation person who works mostly in death now, and representing living people who have lost their most loved children, partner spouses, whether in custody or in other circumstances, I think we have to remember why all of this is occurring now is because of two young men who burnt to death in police custody in Saskatchewan. And it was Julian Faulkner and Kim Murray who discovered when they tried to get some issues around the jury resolved that, oh, we've just completely forgot to put Saskatchewan onto the jury roll. We've completely excluded it. And so that's the impetus that starts that. And so when I come into the office, the first thing that happens is we're arguing Pierre, there's all these things going on. Inquests have come to a standstill, essentially, and have been backlogged for 4 years since. They're now starting to roll out because of the work of the implementation committee. Essentially, though, what really pushes the whole need for the Yakaguchi Review or the recognition where everything results from is a recognition within the coroner process. And so what comes out of that, and Jess referred to this, what comes out of that is this memo from a court services saying, oh, by the way, we've forgotten these First Nations. And that allows, in the criminal sphere, to say, wait a minute, we have a constitutional issue. We need to address that. So as Jessica and Katherine have both pointed out, this has been argued now up to the Supreme Court. So Aboriginal Legal acted as interveners on behalf of the families, 2 families, the Pierre and the Bushy, the King family, that were families of inquest, because when Pierre was one, Pierre McCrae, or Nan and Eden was one, the Crown decided that they were going to ask for a 5-panel Court of Appeal, effectively trying to overturn the Court of Appeals decision. And so we obviously had to get involved in that. And so, in an unusual turn of events, we sought added party standing, which almost never happens in criminal proceedings, and it didn't happen in this criminal proceeding. The bench determined that we would still be an intervener, but we had essentially all the elements of added party, which meant we got to do things that you don't normally get to do as an intervener in the Court of Appeal, which was cross-examine, add witnesses, add evidence. And of course, it was to this. Anyone who ever asked me any questions, I always direct them to Jess, because no one knows this massive record the same way she does, and all of the information the same way she does. So even having a little part of that at the Court of Appeal level, being able to cross and ask questions that we thought were relevant to First Nation people and their participation in jury was very insightful. It was a learning experience, and it enabled us to make really good, strong recommendations, I think, to Yakabuchi's review. So we win at Court of Appeal. Mr. Kakopoulos wins at Court of Appeal. The implementation committee starts, and ALST hosts something called the Inquest Family Circle with Frank Yakabuchi's review team. And so we have families come that are in parts of the corner process. Either just waiting for it, or they've been put on hold because they're First Nations, and don't you know? At one point we were getting letters that said, "Dear First Nation person, since you're First Nation and we don't know what the answer to this is, you're just not going to have your request right now." It literally was happening to some of our clients. And so either they were waiting, they were in the process, or the process was completed. And so the families came together and had an opportunity to spend half a day with the review team and talk about their perspectives. And we had some very vocal individuals. Marlene Pierre, who's referred to a number of times in the Yakabuchi's report, says, put in her own written submissions, and was a zealous advocate on behalf of the families in that space and place. And then when it released, she was right there at the release, and she keeps demanding, to find out what's happening. And so for us, the litigation in the criminal context is absolutely important, because we do the law do work, and we do work around overrepresentation of Aboriginal people, but it's mostly driven by the need to address issues in the coroner's inquest process and to represent these families. For now, we have a backlog of 12. So 12 pending inquests, and one of those is a combined inquest with 6 families. So we actually have 17, right? And so this backlog that's coming up, there's a need, because people like Marlene Pierre say, I don't want a jury that has no First Nation representation to understand how my grandson was first over-incarcerated and put into custody, and then died in custody without knowing all of his background in life. And so this moves us to a point in time when the implementation committee has occurred. So they've already started to implement those big first things, right? So they've done the implementation committee, they put an ADIG in place, they then put in an advisory committee to help them with the various recommendations. And they're having, it seems like meetings, monthly meetings are very regular. I don't know, because I'm not a member of either the implementation committee or the advisory committee, but I often do sit before them in various capacities to share information and knowledge and expertise around some of the issues. And so do other members of ALST. So on that basis, we sometimes know what's going on, but we don't necessarily know everything that's going on. One of the things we do know is, as one of our inquests we're scheduling, after the first round of the W case, the chief coroner said, no more inquests in Thunder Bay or Kenora. So it's like we had progress, we were ready to schedule, we were ready to report on something, it was told, full stop, no inquest till they figure out this issue.
I've been told by the ministry that was my fault.
That's okay, I've been told not by ministry as the institute, but by one particular crowd, that, well, the ALST shouldn't have stirred the pot. We would have found ourselves in this position in the first place. And of course, my response was, yes, let's just continue to ignore the constitutional rights of First Nation peoples. And then I was told, well, Kakopoulos isn't out yet. Yeah. So, I mean, this is... Yes. But Yakabuchi is, and so is the lower decision with, I think, some really good findings. So, where we're at now, though, is when the first case of W came out, and it was determined that it was unrepresented. Full stop. Chief coroner says there will be no inquests. And so it's like essentially the you're still living in terms of putting. But the good news is the work that's happening behind, in the background, is the implementation committee in consultation with like NAN, Anishinaabe Nation, start this process where they're going to the remote communities and really having First Nation band members sign up. So they're doing it's an information piece so that they can educate the communities about why there's a need for it and what it looks like. And then there's this, you can sign up. Here's the paperwork you have to sign up, because Jess mentioned this too. And I don't know how many of you have ever gotten jury questionnaire, anybody? Okay, so if you're a lawyer or a paralegal, you're exempt. There's a little box. But when you go through that, if you actually, we went to the top part, we hit that box, and we don't normally look at the form. You go through the form, and there's so many exceptions, and there's so many threats. If you do not fill this out, you're going to get a $5,000 fine. People stop opening their mail. When one, it's not in their first language. Two, there's threats that are going to be criminalized simply by not answering properly. And so you can see why there's all these issues. So there had to be some advocacy work done and some educational work done within communities to let people know, here's what you're signing up for. So now, what's in place is a protocol only for First Nation representation. It's only going to be piloted, and it's going to be piloted in only a handful of inquests. So it's not full public yet. You can actually find a link on the Corners, I always get their acronym wrong. The Corners webpage, Chief Corners, the Office of Chief Corner of Ontario's webpage. You can find a link that takes you to a document that talks about First Nation representation on juries at Corners Inquest Pilot Project, and that was released in April. So in December, what happened, this past December, is the implementation committee put recommendations forward that the regulations be changed to allow this. So under there's two acts that are involved. There's the Juries Act and there's the Corners Act. But under the Jurors Act, there was no opportunity to volunteer. But through a regulation passed in December that basically said, for the purposes of Corners inquest only, First Nation people residing on reserve can volunteer. But this, so
it might be helpful, Christa, for people who aren't familiar or as familiar as everybody on the panel with issues around openness and issues around Aboriginal jury representation, to just spend a little bit of time talking about what the problem was.
Okay,
yeah, that's right.
Well, we've spent like 3 or 4 years on this, so in our mind we're probably jumping ahead. But if you want to go ahead, you can.
So the challenge that arises from the jury roll system in Ontario is that it's based in the municipal enumeration process, and so the basic inclusion in the municipal enumeration process is all municipal lands that are provincial lands. Landowners and property owners are automatically included. And then the Municipal Property Assessment Corporation has mechanisms for enumerating including others. I learned in preparing for W's case that they have moved actually for the purposes of tenants and others who don't own their homes. They've now moved to a voluntary, you have to get yourself onto the roll. You're actually not automatically included. It's going to be some interesting challenges, I think, from that side as well going forward. And that was recently changed in the last cycle, that they are no longer taking active steps to enumerate on provincial lands for non-landowners, property owners. Putting that aside anyway, it does not include, that database does not include reserve lands, because they're federal lands and not covered by that legislation. And as a result, if the province just uses the municipal enumeration rolls, they will exclude on-reserve residents. The Juries Act provides for the sheriff to go and find a list of reserve residents for every reserve. And it's a permissive section of the Act. It says the sheriff shall obtain a list from any source available, obtain names from any source available. The problem was that the people playing the role of sheriff in Kenora were unaware of reserves, were taking very few steps to actually obtain lists, and since 2000, 2001, Indian Affairs had previous to that point been providing lists of names to the Ontario Jury Centre. After 2001, they stopped doing so, and the only way that those names would come to the knowledge of the sheriff to be able to be selected from in order to receive questionnaires was if efforts were made to have a contact directly with each First Nation to get a list. Needless to say, in Kenora, where there were 48 First Nations that had to be contacted, there was limited success when a single letter was sent out, which was what was done for much of the period prior to 2008. Subsequently, since Kukopanis and since the information came out from these inquests, they are putting in a lot more effort in the ministry. And that effort is actually paying off at the first stage in the sense of getting lists. The quality of the lists is quite a lot better in terms of their age. The problem is that these lists of what they want, what would be useful for jury purposes, don't actually exist. Indian Affairs, this is a whole other story of why Indian Affairs stopped keeping track of who lives on reserve versus off reserve. They no longer keep track of that at all and don't require any list to be maintained for that purpose. It has budgetary consequences if you were to know how many people actually live on the reserves and the number of housing you have on that reserve. But as a result, there are some First Nations who keep this information and some who are willing to share the information that they keep, but many don't. And so for the data that what I have at my fingertips is from Thunder Bay in the last 2 years, when the First Nations send a list, and in Thunder Bay there are 17 or 18 First Nations who are requested to send lists and have been providing lists. The lists, when random selection is made from them, 75% of the envelopes that are sent out to some First Nation reserves come back because the people who have been selected don't actually live on reserve. And so we are discovering, and we couldn't have known this at the point of Acropolis because the ministry hadn't made the efforts at the first stage to be able to tell whether there was a problem with lists. We're now discovering at the second stage that even when you get up-to-date lists, there is still going to be further difficulties. This is it's a process that I think it's a challenge that's rooted in both the administrative technical, but far more importantly, in the challenge of what Yakabuchi called the crisis in the justice system. And just getting lists or just sending more questionnaires is not going to fix that.
I agree. It takes a much more proactive and a more consultative approach to actually engage. It's a requirement to engage. And what I haven't said earlier, but now that you've given this great background, like from a First Nations perspective, one of the things we heard throughout litigation with colonists, and I've heard in other panels and stuff as well, First Nation people don't want to be on juries. Well, guess what? Most people don't want to be on juries. Many people don't actually respond to the questionnaires. So it's not just a First Nation issue, right? But the other thing is, you can't presume that's true if you don't have the information to start with. He's provided information. If you didn't have the information to start with, you can't just work on assumptions or bad presumptions of why Aboriginal people don't want to participate. Having said that, the other side of the coin is, for a lot of First Nation people, the Canadian justice system is foreign. It's mistreated them, and there's never been a benefit to identify yourself as, hey, I'm Aboriginal, please give me more jail time. So, the reality is there's a lot happening at once. And so looking at the technical end and making sure that, in terms of constitutional issue around it, making sure that there's that inclusion in the role is really important, because to completely miss the communities or underrepresented communities is just not acceptable. It's unilateral, it's paternalistic, quite frankly. And so the efforts moving forward have, obviously are coming to fruition, and I agree with Jess, there may be some issues around quality, and there may be other control issues that we'll see that come along. The other thing is the pilot that's going to run is still going to randomly select. It still is on random selection. So essentially what happens is you may get more First Nation on reserve residents volunteering for the pool, the larger pool, but if it's still in random selection, even if you said you have 27 in one region, you said 1,327 were First Nations. Well, what if you increased it up to 500 in that same pool? So you have 13 plus 5. Still, random selection is going to mean that you don't necessarily hit. And so then the question, and this is where legal arguments come in, particularly as it relates to criminal litigation versus things like inquest is, well, if you start hand selecting juries that are not meeting the requirements, the constitutional requirements of the need for a jury and a jury of peers, representativeness doesn't mean that you get to have somebody from your own race on the jury. From a coroner's inquest perspective, or sort of a First Nation person's perspective, it's a lot easier to volunteer and be part of a process that's making recommendations about how to prevent future deaths where there's no blame. So in a coroner's inquest process, there's no finding of blame. So no one is liable. So there might be a determination that the death occurred in one of 5 means, and one of those means can be homicide. But it's not like the inquest can say, and John Smith murdered Pocahontas. There is no blame. And so in that process, that's something that's a little closer to sort of some Indigenous worldviews around collaboration and finding community resolve, or trying to rebalance harmony that's been disrupted. Having an ability to understand, what the circumstances were, what evidence been put for them, and what recommendations. And what recommendations would have real meaning in places like First Nations where people are dying and not getting, because often just remoteness is a factor of getting the services they need. So in that context, the recommendation was number 17 in the report. Moving it forward even through a pilot phase, I think is going to have value. If nothing else, it's going to at least let some of these inquests move forward. Because here's something that I've been arguing about, we actually got an inquest heard during this time, was the family who are Northern Cree, who are traditional, have a belief they can talk about the deceased for the rest of their life, but they're not allowed to talk about the incident of death. They cannot have their final death ceremonies or their annual feasts or do all sorts of religious, spiritual, cultural stuff until they stop talking about the incident of death. You cannot do that if you're going to be a witness in a coroner's inquest and if people are going to publicly be speaking about the death. And so on that basis, we were able to push one through last fall, the NAS one, and because the family waived their right to a representative jury in order, and that was the family's choice to do that weigh and balance, because the death had been 6 years prior, and so you have to start balancing rights and weights. And so moving this forward is a good step. I think there's a lot more to go in terms of communication between all parties, but particularly between ministry parties, the implementation committee, and council on various inquests, to understand that at the end of the day, we still have to recognize the importance and values of having inquests for a quest so that the family can move beyond the death. An inquest is not an Indigenous process per se. But there are actual analogies to what happens in an inquest process that has a lot more meaning to Indigenous communities. It's about hearing some of the circumstance, about publicly talking about it in more of a group setting. It's a jury of 5 people that will hear the recommendations. What happens in an inquest is actually way more involved than that, and I'd say in some ways it's a lot closer to civil litigation and other areas of practice. But at the same time, as long as there's an opportunity afforded. So I don't know if this pilot will be successful. My hope is it will be, because I also hope to not have to take the coroner's office to the Human Rights Commission or tribunal because they refuse to hear First Nation inquests. So every step forward, I think, as long as there's always a reevaluation and a checking in with the impact it's having on the community, and the First Nation community and the families who have suffered the most loss, then there's a value. And so this is why ALST continues to be engaged in this process, or help out whatever way we can. And so it'll be interesting to see what happens. And I have, I've always taken a vision, theoretically, the role will be more representative for coroner's inquest now because of this, but I agree with Jess, the practical reality is we're not going to see a representative role in the next, it's certainly not going to happen by this August. And they pick the roles the year before, so I think it's going to be at least a few years before we see anything even resembling fully representative roles. But we all keep working on it and moving forward.
So you go, my name is Stephen John, Ford, Dr. Lee, Naga, Mohawk Nation, I'm native, Wolf Clan. Unlike my friends to the left of here, I have not moved politics at all over the last number of years. However, I follow it, and I think Indigenous lawyer would. That said, I brought some notes, and I don't dispute what Christa says. I think in that context, she speaks of the representations on Cornish juries. There is, in my view, an opening, an avenue that's necessary. However, the majority, the vast majority of juries, I see the support of this bill, will know that they occur in a criminal context. Okay? So when we look at this, I question what I would call the limited utility of what's happening. Do we want a representative pool, or do we want representative juries? Having a representative pool does not ensure it helps, and I don't dispute that having a pool with Indigenous or Aboriginal inclusion is necessary. But at the end of the day, that may never mean there's an Aboriginal person in the jury. So, if representativeness, what does that mean? Do we describe it as demographics? Because if we look at it that way, we can say, well, 4% of the population of Canada is Aboriginal. Okay, well, how many of that percentage would be eligible for jury? Half? Even if we take that at 2%. Okay? So, on a nationwide basis, if we have a jury pool of 100 people, and 2 of them are Aboriginal, we have representative pool, at least on a demographic level. Okay? 2 out of 100, what's the odds of this person getting chosen? So, when we look at it that way, we have to understand why we want a representative jury. We want that because we want to ensure fair hearing, trial fairness. There's a real possibility in this country that a non-representative jury, a jury made up of non-Aboriginal people, or not including an Aboriginal person, will have some partiality, biases, ingrained stereotypical views. So we don't want that. This isn't new, it's criminal. I mean, back in '93, the Ontario Court of Appeal came up with a case called Parks. And from that comes the Parks question. For those of you who don't know it, it was a black person accused of a crime against the Whites. Justice Doherty in that case came up and formulated a question that could be asked for a challenge for cause. The challenge for cause being, do you hold any biases that would affect your ability to judge the facts of the case fairly? So the question was framed as this: would your ability to judge the evidence in this case without bias, prejudice, or partiality be affected by the fact that the person charged is black in that case and the deceased is a white man? You see why that question is asked. Certainly, if you're selecting jurors, you want to know that. But the process is what we really have to focus on. We have a jury pool. They're called in to whatever court. These are Superior Court cases, only Superior Court with the juries. And let's assume, just for working with what's on the call for that particular case, all of their names are put into a tumbler, a bingo. And they roll it around. And how that works is they draw out 2 names. Now these people will not be on the jury, the first 2 names, but they are what we call the trials. They will sit in the jury. And in the case where there's an Aboriginal person, or in the case of a person with a black person, I have always, in every jury trial I brought a challenge for cause. And how it works is I formulate questions. I formulated questions or questions that I would ask the prospective juror. And based upon their answer, the triers will say yes or no. This person should be unacceptable. But beyond that, the Crown has 12 challenges, and the defense counsel has 12 challenges. So even if the triers say yes, this person is acceptable, the Crown will say no. Now, all of this said, both the Crown and the defense counsel have a list of everybody's name that's in the pool. It tells their name, I believe it tells their age, it tells their profession, the due. So you can kind of go by that as a school teacher. Do I want a school teacher? Or do I want a construction? That's there for you to look at. But all of that said, it's a difficult question, and the challenge for cause hasn't been, and I've read your part question, hasn't been uniformly, at least I'd say this anecdotally, hasn't uniformly been applied in the cases that I've done. I have tried to start with a preamble, and I based that preamble on the finding in a case called Williams, which was a Supreme Court case, which was the Aboriginal parts case. Aboriginal person challenges, the fairness of the trial, of the jury selection process. And the Supreme Court looked at that and said, well, yeah, we have a realistic challenge. And the court in that case, the Supreme Court, was written by the doctor. She wasn't the Chief Justice at the time, she was there. She says, in one part, she says, on the understanding that a jury pool is representative, one may safely insist that the accused must demonstrate widespread general prejudice against his or her race in the community as a condition of bringing the challenge. Well, okay, I talked about representative pool. So if we got 2 Aboriginal people in a pool of 100 people, then I have to show the judge that this community has a bias against Aboriginal people, or it's likely to, and therefore I should be able to challenge. He could say, no, you got a representative pool. You got 2 people on this list. That doesn't sound right. Moreover, in my view, the court went on to say that there are racial stereotypes, and they said the application, intentional or unintentional, of racial stereotypes to the detriment of an accused person ranks among the most destructive forms of discrimination. Okay, that's pretty strong language. It's from the Supreme Court. But I have, as I said earlier, come up with these questions that I was going to ask in the challenge for cause. I mentioned that I would try a preamble. And that preamble would go something like, the Supreme Court of Canada has found that there is widespread racism against Aboriginals in Canada. That has caused some members of Canadian society to hold stereotypical views of Aboriginal people that include stereotypes that relate to credibility, trustworthiness, and criminal propensity. These are important questions. And if that is a fact, the Supreme Court says it is, I want to ask that. I want to put that out as a preamble, because the person knows this question's coming. And then I would say, I would want to follow by 2 questions, not 1 or 2. The first question would be, do you hold any stereotypical views of Aboriginal people that would affect your ability to judge the evidence in this case without bias, prejudice, or partiality by the fact that the person charged is Aboriginal? And the answer would be yes or no. And I can tell you, again, anecdotally, I have seen people say no, and some triers over there throw them off anyway. Because my guess is they were in the back room and said something that they heard. Okay? I've had judges say, are you throwing them off? Was it the question? Yes. The second question, of course, is the straight punch question. And as I said, this has been unusually applied. I have had judges who say, no, you can't have the preamble, you have two questions. I've had other judges say, yes, you can have all three. And other judges say, no, you only have part question. That's it. So, where does this fall in the context of representing jury rules? Something to thought. And in my view, this doesn't work all that well. Now, at the end of the day, I don't mean to steal anybody's thunder. We're going to talk about traditional law and its application at some point during this conference. But in my view, until that day comes, we can apply Aboriginal law in the context of our own communities and our own nations. The criminal justice system will continue to fail us. It has its flawed. It's flawed for everyone. It's particularly flawed for Aboriginal because it's discriminatory. And so the question becomes, does the inclusion of Aboriginal people on jury pools and their reluctance beyond for whatever reason, is this indicative of a concern over assimilation? Is this a situation where First Nations communities and people in them are being told, hey, listen, be a part of the system, it'll be better. Join in. Now, I don't dispute what Christa said about the coroners, because they're quite different than criminal classes. But at the end of the day, is that what's going on? And is that not why a lot of people are saying, I don't want to? I mean, we know that the Supreme Court of Canada has said that they quoted from the Royal Commission in Purdue, said the criminal justice system has failed the Aboriginal peoples of Canada, First Nations, Inuit, Métis people on reserve and off reserve, urban, rural, in all territorial and governmental jurisdictions. It's failed. The principal reason for this crushing is the fundamental different worldviews of Aboriginal people and non-Aboriginal people with respect to such elemental issues as the substantive content of justice and the process of achieving justice. Well, that's pretty strong language as well. So, and that is in 1999. Then one quote from the Manitoba Justice Department, where they say that the justice system has failed Aboriginal people on a massive scale. Then, as we heard earlier, the court said these findings cry out for recognition of the magnitude and gravity of the problem. And the stark figures reflect what fairly may be termed crisis in the justice system. We're at crisis in 1999. If you look at it in terms of voter representation, those numbers have gotten worse since then. So what are you going to call it now? It was a crisis.
So I think it's important to remember or to consider, in light of all this, what you've heard and the issue, what the role of the jury is. As Christa mentioned, in a coroner's inquest, the role of the jury is to hear evidence, see evidence about what happened, to the extent necessary to make findings of fact, in conjunction with the coroner, to inform recommendations to prevent it from happening again. And that's a pretty broad scope. It's inquisitorial and can be fairly holistic. It can include issues like was there discrimination at play, racism, other systemic inequities, historical considerations and factors. All of that may inform the factual findings that would in turn inform preventative recommendations. And that is a much more accommodating scope and process for potential Indigenous jurors, and because it's more consonant with the Indigenous worldviews and more aligned with the interests of Indigenous people. we would like not to die prematurely, tragically, and violently. We would like our children or our relatives not to, have a direct interest in that. I'm going to pick up and sort of amplify what Stephen was talking about. When it comes to the criminal justice system, the jury has a very different and very limited and almost from an Indigenous perspective, arbitrary role. They are to really, their job is to pick from a binary, guilty or not guilty. The evidence that's delivered up to them is strictly controlled by the rules of evidence and procedures that are intended to streamline the evidence so that to inform that choice. Guilty beyond a reasonable doubt, not guilty, based on the elements of the offense. And the jury doesn't even get to sentence the offender, which could be a more constructive engagement if there's a finding of guilt. That's up to the judge. So it's not only that it's a system that is the consensus in Canada. From a policy, legal, historic point of view, it's a system that has always gravely discriminated against us as individuals and as communities, as accused people, as offenders being sentenced, as witnesses, and as complainants or victims. It is a system that is founded on underlying assumptions, foundational assumptions and beliefs that are foreign and not only inconsistent, but contrary to most Indigenous communities, worldviews, laws, customs, traditions. And because all the procedures and the evidence and the constitution of the jury, even the selection of the jury and the task that is given to it, are built on these underlying foundational assumptions and beliefs that are not universal and are not shared by potential Indigenous jurors. It's a very awkward fit as a potential Indigenous juror to walk in and participate in the system that is foreign, discriminatory, and it is wrong for two reasons. One, because it's discriminatory, and two, because you don't agree with the truth, the version of what's right, wrong, how you should deal with transgression, how you assess what is true and what is not true. From most Western world or systems of thought, there is one truth. And particularly in a criminal court, there's only one truth for the purposes of figuring out whether somebody's guilty or not guilty. And that's really not how Indigenous people view the world. You can have many different truths that from a Western perspective would be mutually exclusive, but they can be held in the mind of an Indigenous person or community, and they're not exclusive to each other. So it's a really awkward fit. That said, you walk into, and I've certainly had this experience, I know Stephen's had this experience, if you're a criminal defense lawyer, even if you're in Blue Court, you walk into that room, and it's Aboriginal Persons Court, they were calling it for a while in Toronto, I think they've stopped because I kept saying these things about it. You walk in, and the only Indigenous people in the room are in the prisoner's box. It is not Aboriginal People's Court. It's non-Aboriginal People's Court where Aboriginal people are sentenced or assessed for bail. So it's so wouldn't it be? It's better to have at least the potential for an Indigenous juror. And the competence and the other legal measures that Christa and Jessica and many others have, they're removing a really fundamentally discriminatory piece. It's holding this foreign system to its own values. You can't systemically eliminate and exclude this part of the population because that's the Canadian system not meeting its own imperatives, and it loses even more of the validity, the integrity, the rigor that it's supposed to, fairness that it purports to apply, even by its own values. But and you've heard from Stephen about the limits, and from me about the limits have one Indigenous juror, or maybe two. You know, in Kenora, or there's parts of the world like in James Bay, if there was real fairness and a real effective way of putting together the jury roll, you should have 80%. Like, there's parts of this province where most people, the overwhelming majority of people are Indigenous people. So that should be, but they'd still have to walk into the room and do this thing that, it's not that they're not capable of understanding, it's that it's not what they believe it should be done. So, you know, it's an important, which is not to say that you shouldn't try and get Indigenous jurors on. See, this is one of the, you know, let's hold a bunch of different truths in our head at once. That one, that it's an awkward or possibly undesirable thing for an Indigenous person to be called to be on the jury roll, to participate in a jury. But on the other hand, it's better that it's better for the accused, for the other the people, the witnesses, the victim, the complainant, that there be at least the possibility of an Indigenous person on the jury. So that is all I have to say about. But finally, I think as we go through, and engage with issues around missing and murdered women, the systemic issues that are raised in all the inquests that Christa's working on, that it becomes, if you don't have Indigenous people in the room in every role that has agency, what you end up getting is a bunch of non-Indigenous people speculating about what's going to work for Indigenous people. When you're getting into this problem solving, like commissions of inquiry and inquests. And that is almost invariably works out terribly for us. We have a lot of experience about people trying to do things that they think are in our best interest, and it very never really works out. So if you're going to have processes where concrete actions can or may be taken as a result of the process, then there is no point. And I think it's fair to say most Indigenous communities, leaders, and people would prefer that it not even happen if there's not Indigenous people with instrumentality and agency as the finders of fact, as the people with decision-making power and roles. And as Stephen said, for those of us who are learned, steeped in our own laws, traditions, customs, as well as Canadian legal paradigms, we'd like, of course, everyone would like the Canadian justice system to adhere to its own imperatives in terms of its fairness, integrity, rigor, accuracy. Yeah, that's great. It's never going to work fully for us. It is never going to operate in a non-discriminatory fashion. It is never going to allow us to live as peoples, accountable to each other and to settlers' society in a meaningful way. We can't flourish in the face of these foreign processes because they don't they eliminate the possibility. They actively oppress and discount our truths and our ways of finding truths and our ways of solving problems, dealing with transgressions. So, but that is the process of recovering and revivifying our laws is underway, but it's really just in its, there's little nodes of it happening, and there's a lot of activity, but we're so far from recovering the ability. We assert jurisdiction all the time, but to execute jurisdiction, or exercise jurisdiction, and we're doing it. Do it in child welfare, in criminal justice, all sorts of land use. It's happening, but it's a ways away. So we are. So that's why the work being done to at least make it possible that the system operates fairly is so important. Does anybody have any questions, or does any of the panels have any further comments? Yes?
My name is Julie Peter Carter. I'm not Aboriginal, I have Aboriginal family and friends. We found that one of the best things to get onto a jury pool was to get the young people out there voting, because their name goes on the voters list. They become eligible for the pool. And we also found that there was a way, the way I put it was how to engage to change. And for the last provincial election, basically went around and looked at all the kids who have played since the last previous election and made sure that they got to vote. So that's one way. And I know traditionally a lot of First Nations have preferred not to engage in the political process because they felt that it was subscribing to the status quo, which is still to see what people do. But the thing is, you can hold yourself a citizen for First Nation, but you can also hold dual citizenship and vote in both places. And it's one way of trying to improve the relationship between the two citizenships. From a practical point of view, I was thinking perhaps one of the ways to go about getting greater participation legally was maybe to go to Manhattan and ask for the listings, rather than go to individual First Nations, ask for a database that includes everybody with First Nation status globally, representation of jury.
And for privacy reasons, they will not release that.
But this is the thing is that if you have to mandate that at least one individual on the jury be of First Nations background, Aboriginal status, if the native or defendant rather is Aboriginal, then that might allow that to happen. But there's one agency in Canada that knows where everybody is, and it's totally the state board as a CRA.
Well, yes and no.
No.
And yes and no.
From a privacy point of view too, there's certain shielding there, but if all you're looking for is addresses, because anybody who's can't get on the jury unless you're a legal citizen. So,
But that's a crucial distinction. Many First Nations people do not consider themselves, they're treated by Canada as citizens, but they do not consider themselves to be citizens of Canada. And so this also is another reason why people are eager to serve within a Canadian legal, and they don't vote because they have a government. That's their chief and council, customarily or but under the Indian Act elections. And the government, the municipal, provincial, and federal candidates, are not relevant because they don't consider themselves to be. Yes.
So, sorry, if I could just interject for a second, because you've already raised 4 points. So maybe we try to answer some of those 4 points or comment on them. So, in terms of the last issue, the privacy issue, or the CRA, that's not true. Although everybody's supposed to file their taxes, if you are a First Nation individual on reserve with the eligible tax exemptions, it often goes years and years without, although there is a requirement in law, even if you have zero taxable income, you have to file with zero taxable income. It's not known that people have to do that, so a lot of people don't do it because they understand their Indian Act exemptions to mean that they don't have to. So the CRA doesn't know all of it right now. And if anything, the exercise that Katherine has taught me is, despite how many maps and how many things we went through, one of our recommendations, ALST to Yakuchi's review was get a map that has all the First Nations on it and make sure that Court Surfaces knows where all the First Nations are. And like some of those real practical things. I tend to agree with Katherine, but I don't want to speak so generally that we lose. There are a lot of people. In fact, I'm a First Nations person. I live off reserve, but I have interest in community and property on reserve. And one of the things I always do when I'm talking to my community is encourage them to vote. I stand in front of game artists and encourage them to vote. And so we can't just fall into a presumption that that doesn't happen. And then there's other legitimate reasons why people don't. So I think, there's all these great ideas, and there's like a lot of brainstorming that's going on around things in terms of managing. But to take a step back, and Jessica said this, and I believe Stephen said it, and it's just a different way, and so is Katherine now. It's not going to be the questionnaires It's not just about getting the address or the questionnaire to the individual that's going to resolve this issue. And that's the truth. That's not the biggest problem. It's not about having someone try to read in a foreign language and all sorts of things. The biggest problem is about trying to get to a place of representativeness in what arguably is a foreign system. And what drives me, or my passion in this, and this is what I submitted to Yakubuchi, and so we wrote to Yakubuchi, is exactly what Katherine touched on. It's administration of justice. It has to meet its own standard. And the reason why I do this work, and I'm split, like Katherine is kind of just, I'm a First Nation Islamic way. I would love to know more about Ganapagaon and my culture's use of stuff, but I'm a Canadian lawyer too, right? And this is that fine line we often walk, is these two worlds. But the reality is, whether I like it or not, my family, my friends, my cousins, my brother and father, they're over-policed, they're stopped because they're brown, people are incarcerated, and whether I like it or not, despite whatever I am, that's going to continue happening. So I'm going to demand that my people have the same constitutional rights as every other individual within their own system, and that system is going to be accountable. And so there's a lot of things that could be brainstormed, and I think a lot of them have been thought about, and so they're good ideas, and there's actually places, you could write to the implementation committee some of these ideas, because that might help. Yes. Professor Ebert.
He was kind of cagey about it, but I think that Justice Yakubuchi pretty much acknowledged in his report that a lot of the people he talked to wanted the Canadian justice system to be pushed aside so that First Nations could be subject to their own justice systems, their own criminal law. And I know that there are communities that are now starting to try that. So I wonder if focusing on the jury role, which is a very small part of the systemic discrimination in the Canadian justice system, is not going to distract from the efforts to solve the real problem, which is the imposition of Canadian criminal law? Or do you see a way that the two objectives can work together?
Nice easy question.
Yeah. I would say strategically, it was a good place to start. It's one of the only places where the state requires Aboriginal people rather than just not caring much at all. So you can prosecute Aboriginal people without requiring any buy-in from their communities. The point at which there was a need for the state to figure out what was happening and even just to inquire. It's about the only area in law where the state has taken seriously a duty of consultation in a real attempt year after year, because they keep getting it wrong, to make it better, to put more resources in, to really look at the broader issues. I don't know that you would have got that buy-in from the state if we weren't stopping jury trials in the north. Now, there really aren't that many jury trials in the north. There's one a year maybe in Kenora, and maybe two a year in Thunder Bay. But it has this broad ripple effect of the sense that the criminal justice system was grinding to a halt. And that gets the attention on, at 720 Bay to actually look more broadly. So I think strategically, it is a good place to start, because it's a place where the state has no choice but to look. The challenge is, I think in the next rounds, the next few years, the state is going to be able to say, and the judges are going to start finding, that they are doing administratively what they're required to do to meet basic standards of competence. Like, they found all the reserves. My favorite moment in one of the cross-examinations was being told that the reserve had moved. The map was cut off by the photocopier. The reserve had not moved, it was where it always had been. So they found all the reserves, they are beginning to use the right phone numbers, they understand now the difference between a reserve and a First Nation, which was also something they hadn't figured out. So at the basic level of administrative competence, they have succeeded. We are not going to see much of a change to the jury role out of that. So when the state starts having jury trials that continue, that start up again, where is the impetus for continuing efforts on the implementation now? And that's going to be the challenge. I didn't answer your question at all, I just done.
Look at Yakabuchi's interpretation of his mandate. That was it's a good leverage. That's what he did. He took this little, you're to examine this little thing, and he said, "What's wrong with the justice system?" That's what he, So, so that was good. But you can see, I agree, in the tenor of his report, it's kind of like, well, yeah, they keep talking about jurisdiction, but anyway, there's discrimination, right? So it's really his orientation and his loyalty is to the Canadian justice system. Fair enough. That is what he's lived his professional life. He is he's a foundational player in that, and he's steeped in it. And he's a member of the dominant culture, the legal body politic that came up with it and implements it and imposes it. That said, he's a great friend. So
for sure, but like in terms of if you focus energy on this, then because one of the things we think about is if you focus energy on this, we're getting the buy-in from the Indigenous community into this. Is there fear that other things like within their own jurisdiction now? I'd say no, because again, they're not mutually exclusive. And we look at somewhere like Anishinaabe Nation, the Union of Ontario Indians, and the types of processes they're putting into place. You can even see it in an urban context, but slightly different with ALST and the types of community Aboriginal justice and processes we. And part of getting this buy-in or this starting point, also, because I say this all the time, it's not going to happen in my lifetime, I think. Maybe when I'm ready to retire, we might see some more traction. But these slow wins, these slow buy-ins, and this awareness that occurs, like when we recognize that there's a group that's being constitutionally discriminated against on certain basis, it can only raise the thing. And what we see is progress. And what does that progress look like? Well, it looks like a lot of things, but one of the arguments I always get into is because Aboriginal does programs in an urban context, not a First Nation context. And I'm actually not the program director, Mr. Colin Rudin is. But at the same time, they're like, well, it's not really Aboriginal justice. No, it's not Indigenous traditional justice. It's an Aboriginal friendly process using Aboriginal community members to within a process within a Canadian criminal justice system. But don't forget, just this whole idea of freezing in time, we can't freeze in time. We have to progress. And so what does it look like as it changes? And I think that you can have both happening. I think you can hold to account the government, the court system, like the executive, all of the branches of our country and our government to the standard that they set at minimum. And that's one way to progress issues while still embracing and reviving Indigenous legal traditions. And I think what you'll start to see is more of an acceptance and potentially more jurisdiction over time. Again, I'm really fear it's not going to happen in my lifetime. There's going to be a wholesale acceptance of Indigenous legal tradition, although it really does inform Canadian law more than most people are aware of. But, I mean, it is what it is. I think, we take these little wins. We have to keep taking these little wins. The alternative is to feel defeated and not proceed, right?
And it is an important distinction. I do about 50% of my practice is Indigenous child welfare for First Nations, and we did a big round of statutory reform consultations over the last year with the Ministry for Child and Youth. And 201, every organization, community, entity, and individual I work with, Indigenous, prioritize jurisdiction, which has been asserted continuously, but hasn't been exercised effectively, or exclusively in Ontario. It's been exercised in one community in BC, Wisconsin. So, and we went through all these meetings, and so 2 years ago we were dealing with senior government officials, and they were saying, we'd say jurisdiction, and they'd say, we would like to give you control over these statutory processes in the Child and Family Services Act and Child Protection. And everybody's like, and we'd say, no, jurisdiction, Indigenous law, and they'd say, yes, we'd like you to control the increment, and over again. And within the last 4 to 6 months, the ministry has heard it. Oh, your laws. You are not authority delegated from the provincial crown, but your inherent exclusive authority. We're not agreeing that you have it or should be able to exercise it or that we should resource it, but at least we understand what you're talking about. I swear, 2 years ago, these are people with senior policy, like, deputy ministers, and they weren't being obstructive or deliberately obtuse. They just couldn't hear it. They didn't have the equipment to understand it, and now they do. So, and in criminal justice, I mean, it's a bit further away. There's been a lot of work done on child welfare in the child welfare front, but.
Well, that was my point. Katherine and I looked at it and said, Christa, this challenge that they've brought is part and parcel of the challenges we all bring as Indigenous lawyers. My clients are all Indigenous. And I stay vigilant for every opportunity where I can push either their law or to point out the flaws in their law that they have to accept. They don't like it. I don't care. And that's what this is. They've cracked an egg here, and it's a good start. And every opportunity we have to take those opportunities, because at the end of the day, once we can show enough body of evidence of the flaws, and there's lots there now, but as we continue to say, this is flawed, and you have to change it. This is flawed, you have to change it. To the point where we buy time for those who are working on developing our Indigenous laws to come up with it in a manner that they can be implemented in a setting they can be implemented in, such as tribal courts, if you will, just by way of example. Then we've done something, so we got to keep trying. That's what it's.
We have about, probably 2 or 3 minutes left. If anybody, does anybody have any other questions, or anybody on the panel can say anything else?
We have the next panel that's actually starting at 4:30, and that is on Indigenous legal traditions.
Well, there you go.
And one of the panel members is in here, so they're not going to start with them.
60 pages finally received classifications, class actions, certifications on it. So one of the things that I would like to know is that it's not just people with the materially affected by who should be in the courts, but all the allies need to be there so that the government of Canada and the courts know that everybody cares about what's happening.
Good point, good point.
Good.
More allies, yay!